Welcome back. You are watching KTN News Desk with me, Akisa Wandera, and joining me in studio now is an advocate of the High Court, Dancun Okach. Of course, Justice George Odunga has ruled that the Judicial Service Commission should reconsider those who had applied for the position of Chief Justice, Deputy Chief Justice, and Judge of the High Court, or the Judge of the Supreme Court, beg your pardon, and they should not submit the names or make any recommendations to the President. And this is what leads to our discussion at this hour on the intrigues as we search for the next Chief Justice. Duncan, we have a timeline, we have elections coming. With this push and pull we're witnessing in the Supreme Court, where does that leave us as a country?
That leaves us as a country in a very precarious position. And as you may recollect, Akisa, you'll know that we would have already embarked on this process way back had it not been for the stay orders that some of the former judges of the Supreme Court had obtained. Therefore, we were supposed to hit the ground running. No time wastage, no room for mistakes, and no room to even make any Kenyan go to court. However, and from what I'm seeing, chances are very high. We've not seen the end of the court battles yet. We are just at the beginning, and as you truly note, we are at a precarious position as regards the next general elections and the issue of presidential election petitions.
This drag on and push and pull, could there be politics at play that will affect the next the incoming Chief Justice once we find one? Very
true, Akisa. There is a lot of politics in this particular process, and that may have well informed the reason why some of the contestants didn't even qualify to be shortlisted, and the reason is the very function of the Supreme Court, and especially the head of the Supreme Court, in as far as determination of presidential election petitions are concerned. And also the Supreme Court makes decisions which are binding to all other courts. And that is why you've had the judges in their colloquium last week saying that they will prefer that the Supreme Court only deals with the presidential petitions, but all these other petitions end at the Court of Appeal because of the politics which is at play. But the politics is not only based on the national politics or political parties, it is also internal. LSK has a lot of stake. We have groups within LSK that have formed, and they're calling themselves cartels A and B, all fronting their own people. But it is normal in any procedure like this, you expect such push and pull. But what is important is that the process should be beyond reproach. It should lead to a candidate who is best qualified, not factoring in these other push and pulls from exterior places.
These cartels that you mentioned, and of course it's not the first time we've heard of cartels, not only in the law society, but of course in the judiciary as well. We've had even lawyers, judges themselves say that there are serious cartels in the judicial system in this country. Just how much say do they have, and how would this affect the picking of the next Chief Justice, Deputy Chief Justice, and of course the Judge of the Supreme Court?
Akisa, these cartels have a lot of say. If actually they didn't have, we will not be in the position where we are today, whereby there's back and forth push and pull. That is a testimony of their powers and the control that they have. And it is something that other quarters are trying to fight, which is a good thing, so that decisions such as these or processes such as these are actually protected, and that is the constitutional framework of it. You protect them, you canvass them, such that any exterior factors do not come into play. And I'm sorry to say that that has been the case, that has been the norm. And I pray that with this particular process, and especially with such good decisions like the one that Justice Odunga has just delivered, people will come to know that the Constitution is at play, and it will protect and preserve itself.
Conversation that I've seen online is that after this particular ruling by Judge George Odunga is that why would the Judicial Service Commission go ahead and do something that they know is against the law. They definitely did have the idea that what they did was against the law, so why did they do it, knowing that the law would still catch up with them at some point?
Akisa, the reality is that it was not so much as against the law. If you look at the decision itself, it does not force them clearly as having contravened the law per se, but it actually says that yes, the constitution will give you certain powers. The constitution cannot be specific to the nitty-gritties, and that is how constitutions worldwide are actually made. And we even have unwritten constitutions in other countries. However, they give you some liberty in terms of how to conduct certain aspects. This liberty must be guided by the same constitution and laws there too. What the judge has said is that yes, you have the powers to choose or to undertake the process that will lead to us having a new Chief Justice and the rest. However, that process must actually factor in the cardinal aspects of the process. That is, you must remember that the process itself should lead to the appointment of a particular individual who will actually have an effect on the lives of each and every Kenyan. Therefore, that process must be so open, so clean. The considerations must not just be from left, right, and center. They must be tailor-made towards ensuring that we have this particular individual. However, if you bring out other qualifications which do not add any value, they don't have any probative value, the court is saying that those considerations may actually be geared just to lock out persons, and they don't have anything to deal with the qualifications and criteria that were published when when the JSC invited applications from Kenyans.
So what options does the JSC have now?
The JSC has the option to appeal. Yes, that is on the ground. Personally, as an advocate and as a Kenyan, I would not expect them to do that, based on the same issues that you told me that you actually alluded to, interests and of time, which we obviously don't have. Therefore, I would expect them to take the second option. That is, they will say, yes, we will review this, and a reviewal will have two limbs. It is either an internal reviewal, and they will actually then say, we have reviewed and we have, based on what the court has said, we have added these persons to the list, and we will allocate them dates for the interviews. Secondly, they may say, well and good, if that is it, then all these people who applied, we will actually give them a hearing based on the time. They may reduce the time frame and all that. Whether it will affect the quality in terms of the interviews or not, that's another issue.
After all. All right. Thank you very much. I understand we do not have too much time. This is a very expansive discussion, and we'll definitely be seeking to have it with you and, of course, the others in the society and the judicial